Hello, everyone. So, welcome back to the Law Learning Capsule. And on this episode, we are going to talk about the history and development of English law and the common law. So, let me first state that with the history and development of English law, there were three phases that emerged in the development of English law. The first phase was the development of the common law and the common law courts. The second phase was the development of equity, and then the third phase was the fusion of equity and then the common law. So let me start with the development of English law and the common law courts. So back in the time, there was series of warfares that used to go on in the past, and then amongst these wars there was a prominent or a dominant one which was known as the Norman conquest of England in 1066. This war generally it marked the beginning of the history of English law. So the Englands were basically going on warfare with the Romans, and these Romans were then known as the Anglo-Saxon people. So that was the period in which they were in was called the Anglo-Saxon period. And with this, because of this back and forth with the people of Rome or the Romans, England was not united and did not have any central administration, and there was basically no uniform legal system at the time. So then the local courts were presided over by bishops and earls. So by that time, it wasn't judges that were presiding over their local courts. So at the time, it was bishops and earls, and some of them are even people in higher positions with higher knowledge of the law that stood in that position as judges at the time. So then there was one king of England called William the Conqueror. So William the Conqueror, between the times of 1026 and 1087, he defeated the Anglo-Saxophonist people when they went on a battle. So it was after this war that he introduced a strong centralized system of administration over the whole of England. So then he separated the church and the state. So the bishops were removed from the local courts, as I mentioned earlier, and then a separate system of courts was created, and that system of courts was called the ecclesiastical courts. You understand? So then with this particular system that emerged, they separated the church from the state. You see, the church was headed by bishops, so they had to remove the bishops from the local courts because their place was supposed to be in church. So they heading the local courts, he separated them. And for that matter, let's move on. So then the Normans created a uniform and common law based on the unification of the diverse local customary law. That's a point to note. So then one of the major things we have to also take out is that, so at the time there was something called the Curia Regis or the King's Court. These Curia Regis, they were names given to council of advisors and administrators in the medieval times. So at the time, these people were kind of like advisors, and they were combined with the executives, the legislature, and the judiciary, or they had combined powers of the executive, legislature, and judiciary. So the king at the time, right? The king at the time was regarded as the fountain of justice and the keeper of peace. So with this, powers was handed over to him, or that king at the time, to ensure that there's order and peace in the kingdom. So then the Curia Regis functioned as the highest court by that time in England, and its judges interpreted the common law. So then the judges of this court, so you can see that it's from here that they actually started getting actual judges. So the judges in this case were the ones that interpreted the common law, and at some points they used to travel on circuits. And when I talk about circuits, they used to move from one local court to the other and continue to function. So looking at the workload that kept emerging, the Curia Regis or the King's Court split into 3 royal courts. So these courts were known as the Exchequer Courts, the Court of Common Pleas, and then the King's Bench. So then the royal courts were centralized in Westminster. And as it was in Westminster, there were judges from these courts that went on circuit to hear local disputes twice a year. So when these judges leave Westminster, they go to local courts to go and listen to the local disputes twice every year. So please note that they do this twice every year. And this practice was basically there to reduce the workload on the courts and also the jurisdiction of the local courts. So during the 15th and 16th century, the practice developed of difficult cases being adjudicated in Westminster. So within this period, the 15th and 16th century, difficult cases sprang up or arose, and all these cases were adjudicated in Westminster because that was where the royal courts were. So when these issues arose, then solutions will be found for the issues, and then the court will give its verdict. So this led to the development of a system of binding precedents. And when we talk about precedents, it means standing by an already decided authority. So this was when the courts adopted the system of stare decisis, that is standing by previous decisions developed. So if, let's say, you go to the Westminster courts and the case is on a particular matter that is very difficult to adjudicate, and then the courts finally finds a way to adjudicate that particular case or to determine that particular case, and a subsequent case arises, the courts and the subsequent case arises and has the same set of facts or the same issue to be dealt with, the court will pick the decision in the previous case to decide that of the new case that has been brought to the court. So it's from this that civil actions in common law were also built, and with this particular period, there was something called the writ system with regards to the civil actions. So if you want to bring an action in court and you are a plaintiff, you must obtain a writ. And these writs, they are basically commands from the Lord Chancellor in the King's name. And that writ will order the defendants to appear in court and show why the plaintiff should not be given the relief or should not be given the remedies to the issue he has brought or the claims he has brought. So let's say, for example, I go to court and it was for the claim of land against a defendant. So if, let's say, I'm claiming title to the land and I want my action to be heard in court, I bring an action in court by a writ, and that writ must be was issued by the Lord Chancellor, and he was doing that in the name of the king. You understand? So if he does that, then that writ will be sent to the defendant, and the defendant has to show cause or has to show why the plaintiff should not get reliefs to the claim that he's trying to seek. And this is done when he's ordered to come to court. So if the writ system, or basically, if the rate that you pick up does not, if the relief you are trying to claim does not fall within a particular rate or particular rate system, then you basically have no remedy. You understand? So this was called the no rate, no remedy type of problem at the time. So with this one, the extension of the law was severely limited, and because it was limited, it prohibited the issuance of new rates by limiting it to those that were already available. So at the time of 1258, like that period, the rate system was very, very limited. Like the rates that were available were very limited. So you go, and if maybe your rate was if you maybe wanted to seek relief for defamation, or wanted to seek a relief for assault or battery, and then the only rate that was there was for maybe false imprisonment. You can only bring an action for false imprisonment, but you can't bring an action for assault and battery, because there was no remedy, because the rate did not spell it out. And then the Lord Chancellor basically made those rates specifically for particular offenses. So if those rates do not fall in the scope or in the field of your offense, your action or your relief that you want to seek, you basically have no remedy. So due to this, the existing rates were applied to cases which were not originally meant for. So English judges developed the practice of creating laws from case to case, and then this has continued till this day. You understand? So this is the end of the history and development of the common law and the English law courts. Thank you.